Be ready. Start. The function of the court is to see that lawful authority is not abused but not to appropriate to itself the task entrusted to that authority. It is well settled that a public body invested with statutory powers must take care not to exceed or abuse its power. It must keep within the limits of the authority committed to it. It must act in good faith and it must act reasonably. Courts are not to interfere with economic policy, which is the function of experts. It is not the function of the courts to sit in judgment over matters of economic policy, and it must necessarily be left to the expert bodies. In such matters, even experts can seriously and doubtlessly differ. Courts cannot be expected to decide them without even the aid of experts. We do not think that it is the function of this court or of any court to sit in judgment over such matters of economic policy as must necessarily be left to the government of the day to decide. Many of them, as a measure of price fixation, must necessarily be are matters of prediction of ultimate results on which even experts can seriously err and doubtlessly by differ. Courts can certainly not be expected to decide them without even the aid of experts. The judiciary cannot engage in an exercise of comparative analysis over the fairness, logical or scientific basis or wisdom of a policy. It held that the court cannot strike down a policy decision taken by the government merely because it feels that another decision would have been fairer or more scientific or logical or wiser. The wisdom and advisability of the policies are ordinarily not amenable to judicial review unless the policies are contrary to statutory or constitutional provisions or arbitrary or irrational or an abuse of power. To summarize, in the context of the present reference, it needs to be emphasized that this court cannot conduct a comparative study of the various methods of distribution of natural resources and suggest the most efficacious mode if there is one universal efficacious method in the first place. It respects the mandate and wisdom of the executive for such matters. The methodology pertaining to disposal of natural resources is clearly an economic policy. It entails intricate economic choices and the court lacks the necessary expertise to make them. As has been repeatedly said, it cannot and shall not be the endeavor of this court to evaluate the efficacy of auction vis-a-vis other methods of disposal of natural resources. The court cannot mandate one method to be followed in all facts and circumstances. Therefore, auction, an economic choice of disposal of natural resources, is not a constitutional mandate. We may, however, hasten to add that the court can test the legality and constitutionality of these methods. When questioned, the courts are entitled to analyze the legal validity of different means of distribution and give a constitutional answer as to which methods are ultra vires and intra vires the provisions of the Constitution. Nevertheless, it cannot and will not compare which policy is fairer than the other, but if a policy or law is patently unfair to the extent that it falls foul of the fairness requirement of Article 14 of the Constitution, the court would not hesitate in striking it down. Finally, market price in economics is an index of the value that a market prescribes to a good. However, this valuation is a function of several dynamic variables. It is a science and not a law. Auction is just one of the several price discovery mechanisms. Since multiple variables are involved in such valuations, auction or any other form of competitive bidding cannot constitute even an economic mandate, much less a constitutional mandate. In our opinion, auction, despite being a more preferable method of alienation, allotment of natural resources, cannot be held to be a constitutional requirement or limitation for alienation of all natural resources, and therefore every method other than auction cannot be struck down as ultra vires the constitutional mandate. Regard being had to the aforesaid precepts, we have opined that auction as a mode cannot be conferred the status of a constitutional principle. Alienation of natural resources is a policy decision, and the means adopted for the same are thus executive prerogatives. However, when such a policy decision is not backed by a social or welfare purpose and precious and scarce natural resources are alienated for commercial pursuits of profit maximizing private entrepreneurs, adoption of means other than those that are competitive and maximize revenue may be arbitrary and face the wrath of Article 14 of the Constitution. Hence, rather than prescribing a method, we believe a judicial scrutiny of methods of disposal of natural resources should depend on the facts and circumstances of each case in consonance with the principles which we have culled out above, failing which the court in exercise of power of judicial review shall term the executive action as arbitrary, unfair, unreasonable and capricious due to its antinomy with Article 14 of the Constitution. Thank you.